Hello and welcome everybody to our 10th session of the Esport Lunch Lectures in Germany. As always, we will be recording this session, while for the presentation, the Q&A afterwards will not be recorded. And today I can welcome my colleague Alexander from Frankfurt. He's our head of employment law at SKW, and he will tell us a bit more about fixed-term contracts in Germany, which are very essential for esport. And with this, Alex, the stage is yours. Have fun.
All right, thanks, Moritz. Thanks for having me here. It's a pleasure to give you a brief insight about fixed-term contracts in Germany and how this is essential in the pro sports, in particular in the esports industry. So we start with the presentation, and before we talk about the fixed-term contracts are basically essential in an employment environment. We have to briefly discuss the question, how do I actually employ players in my team? So in Germany, you basically have two means how to employ a person. It can either be as an employee or as a freelancer. Both means have advantages and disadvantages, obviously. And with the freelancers, typically a means which is from a commercial and financial perspective might be more attractive, but we'll see that it is not really relevant when it comes to actually pro sports. So an employee is typically employed on an employment contract basis, which is pretty obvious. And based on this employment contract, the employer is entitled to give instructions on time, location, and the actually kind of performance of work. Whereas the freelancer is only employed on a service contract basis, and he's more free in deciding what he wants to do and how he wants to do things. So how is this of essence when it comes to pro sports? Because I have the experience that many pro sport athletes and also in the esports industry consider themselves more or less rather as artists in some way. So a category to which freelancers would basically fit. But obviously, teams will always go for the employment contract basis. Why is that? For sure, you want your player to play at a certain date. You want to have your players do streaming. And for sure, you also want your player to attend merchandising events. And you can only instruct and basically enforce these obligations if you employ that person on an employment basis. So the employment contract is the way to go. And just a brief overview on this. I mean, it has many advantages for all basically stakeholders involved. The team for sure has more or less full control over the player and how he or she performs the duties. It is also pretty reliable since employment relationships are typically more stable than freelance contracts. And it also accrues the attractivity of the whole industry since it is more stable and reliable for the affected stakeholders. So having answered this, that you employ your players on an employment basis, next question always is, shall it be on an indefinite term or shall it be a fixed term? The indefinite term is, from the German legislator perspective, is just the market standard form to employ employees in Germany. Why is that so? Various reasons. For sure, the political, let's say, influence is there that you want employees on a indefinite contract, and it is also, at least per the perspective from the German legislator, it's also not a disadvantage to the companies since you can basically get rid quite easily of an employee if you want to terminate, at least in theory. In practice, it is much different. So since the indefinite contract is the rule, the fixed-term contract must be the exception, and every exception always requires a special justification. The justification for fixed-term contracts is in a special act. In German, Teilzeitbefristungsgesetz, so the act on part-time work and fixed-term contracts. And since, just to give you the overall idea, since it is an exception, the exception is ruled very strictly by courts. So whenever there is a dispute about the permissibility of a fixed-term contract, it is really handled quite strictly by courts. The indefinite contract, as said, is the market standard, and this is, among others, based on one fact. The German legislator assumes that employees always have to work until statutory retirement. And you will not get into statutory retirement on a continuous fixed-term contract basis. Moreover, it typically requires an indefinite contract. This is important, which we'll see in a couple of minutes, just to understand from where the German legislator is actually coming from. What are the typical justifications in Teilzeit- and Befristungsgesetz? So how can I basically excuse giving a fixed-term contract? So the respective act provides for 8 specific reasons. And those can be read and understood quite easily. We will come to which will be essential for the esports industry. But other than those 8 reasons, there are basically no other statutory reasons why you can employ somebody on a fixed-term basis. So anything that falls not in either of those 8 categories, you have a legal issue. But there's an advantage for certain companies and for certain candidates. So the first shortcut basically is that you can employ somebody for 2 years, for up to 2 years, without giving any specific reason. So you don't need any justification, you just have a fixed-term contract. The only condition for this is that that person has never been employed with the company or the team before. If that was the case, and even minor employments, we cannot go on this road. The justification will then not uphold if disputed. The second shortcut is a privilege for new companies, and if you apply that exception, you can even employ somebody for a fixed term of up to 4 years. But what is a new company? A new company, from the legislative perspective, is really a new company. So what does not work is that you have an affiliate in Germany, for instance. You already have this, and then after 4 or 5 years, you think, all right, let's set up another affiliate, another affiliate of the already existing company, and shift all employees into that company, and then start all over again. And then after 4 years, do it again. For sure, this is more or less obvious that it is a circumvention of statutory rules. So a new company is really a market entry scenario, so to say. So for some companies it might work, but this is an exception that not a lot of companies are really aware of. So if it is of interest, you should keep this in the back of your mind. So what is then the typical justification for the pro sports industry in general, and for the esports industry in particular? I titled that slide the Heinz Miller verdict. Who is Heinz Miller? It's not a John Doe in Germany. It is a really existing person. He was a very good goalkeeper for Mainz 05, which is a German Bundesliga team. And he was employed, as many other players in the pro sports industry, on a fixed-term basis. Once there was a dispute about contracts, about bonus payments, the team then decided to not extend his last fixed-term contract, but they just let the term expire. And Heinz Miller was not really happy about it, and he went to court and disputed the permissibility of that fixed term, of the last fixed term agreement. And to the surprise of all parties involved in the first instance, he won. It was really a huge, it was an earthquake to the pro sports industry, since people were now unsure, is the whole system basically at stake? Because if you only can employ players on an indefinite basis and fixed term contracts do not really work, then we have a huge problem in many fashions. Luckily, the appellate court and also the federal labor law corrected that verdict and basically confirmed that there is a special justification, so to say, when it comes to pro sports. But the Federal Labor Court started the whole verdict by saying the mandatory rules on part-time fixed-term contracts apply to all cases, no matter which industry. So there are no special rules, special laws, at least until now, regarding pro sports. But the Federal Labor Court was pretty wise and looked at the looked at the facts about pro sports, and they say that the working conditions in pro sports are fundamentally different than from a regular employment. Unlike regular employees, pro sport athletes, at least in, I would say 95% of all sports, cannot perform pro sports until they reach retirement. And we saw on the third slide that this is one of the main justifications for the legislature's assumption that an indefinite term is the general market standard rule for employing employees. The Federal Labor Court now said this is not true when it comes to pro sports. Moreover, an indefinite term is rather the exception, looking at all data the Federal Labor Court could gather, and it went on to say that a fixed-term contract is actually the market standard when it comes to pro sports. So, with regard to one sports, for sure, this was very welcomed, and it relates to German soccer or football, because the Federal Labor Court explicitly said that this ruling applies to all basically pro football cases, and it was confirmed in subsequent cases. So the question, which is why I highlighted it with open, is it only applicable to football or also to hockey, basketball, tennis? And for sure, you are interested in esports. It is not decided, yes, but the way the Federal Labor Court approached this case, it is more than certain from my perspective and from many other experts' perspective that they will apply this reasoning to all other pro sports. And we all know that when it comes to esports, it is even more applicable to esports, since it is tough for esports athletes to perform esports until they are 35, 37. I mean, in theory, possible, but in Germany, you have football players that are 39 or 40. It is currently rather unthinkable when it comes to esports. So I'm very optimistic that when it comes to that discussion with an agent or with a player, or even with a court, with the judge, that we can validly rely on this verdict and basically justify any fixed-term agreement with an employee. Why are fixed-term contracts also very important? And this is also something that the Federal Labor Court explicitly approved in that Heinz Miller verdict. It is fundamental to the transfer ecosystem. Without fixed-term contracts, if fixed-term contracts are not permissible, only indefinite contracts work. And an indefinite contract you can always terminate by obeying the applicable notice period. So an employee can leave the team within 4 weeks. So this will be detrimental to the whole system. You will never basically again receive transfer fees. And I mean, transfer fees are fundamental for the whole system to keep the funds flowing, and also have minor teams basically make money out of investing into their own players. So this will also apply to the esport, or it does apply to the esport industry. So this is an argument that will definitely be heard by a labor judge when that labor judge has to decide on the permissibility of a fixed term agreement. So with this, my 15 minutes of fame expired, and I'm happy to hand over again to my colleague Moritz.